In 2011, the town of Dryden passed a resolution banning the process of hydraulic fracturing, or fracking, within its borders. In response, a natural gas company looking to drill in Dryden sued the town. And this set off a legal battle that 3 years later has made it all the way to New York's highest court. The question is whether a town can use the doctrine of home rule to keep fracking out. And here to talk about the case, what happened with the case this week at the State Court of Appeals, and what the possible rulings could mean is Helen Slottje, a recent winner of the Goldman Environmental Prize and a co-founder of the Community Environmental Defense Council. Helen, thank you for joining me this evening.
Thank you for having me.
So I mentioned that this got started back in 2011, but I'm wondering if you could kind of lay out for us how that case got from there to where it is now.
Sure. So in August of 2011, the town of Dryden passed an amendment to its zoning code, making it clear that drilling, exploration activities, gas drilling, were not a permitted land use in the town. And Anschutz Exploration Company, a Denver-based oil and gas company owned by one of the world's billionaires, Philip Anschutz, sued the town because they had some leases in the town and they felt like they should be allowed to go ahead and drill for gas, even in residential or areas that the residents didn't think were particularly appropriate for gas drilling. And the basis for this thought was that there is a state statute that says that only the New York State Department of Environmental Conservation, the DEC, can regulate the oil and gas industry. And industry took the position that if you couldn't regulate the industry, you couldn't use land use to make that a prohibited land use. So they brought suit shortly thereafter in September of 2011. It was heard here in Tompkins County. So they brought suit in September. It was heard in November. There was a decision by February of 2012, and the town was victorious in that case. At that point, Anschutz decided they weren't going to continue the appeal. They were going to drop it. They sold 2 of their leases to Norse Energy, and Norse Energy pursued an appeal. So they filed their appeal. Papers were filed, and that was heard in March of 2013. By May of 2013, there was a decision issued in that case, and once again the town won. And that was a unanimous decision, 4-0 at the appellate level. At that point, shortly after that, Norse filed for bankruptcy, and Norse got permission from the bankruptcy trustee to have the bankruptcy trustee continue the suit, and they appealed to the Court of Appeals, the highest court here in New York. And that was heard this past Tuesday, were the oral arguments in that case. Again, with the basic issue being, does the fact that the state is the only entity that can regulate the oil and gas industry, does that mean that communities have no say about simply prohibiting the industry, not trying to tell them what to do, how deep they can drill, how much insurance they have to have, how much cement they have to put in the well casing, but simply saying this isn't an appropriate land use. There is no place for this in our town. We looked and it just isn't a fit. And is that really the sort of activity that the state meant to preclude when they said you couldn't regulate the industry? Mm-hmm. And none of the courts so far have thought that was what the legislature meant. They all thought, no, you still have your land use authority, you just can't regulate the industry. You can't tell them, these various operational procedures. So oral argument was this past Tuesday, and we should have an opinion. They usually issue opinions within 4 to 6 weeks, which would be the very beginning of July.
And you kind of mentioned that the question is whether a town cannot necessarily regulate the energy exploration within its borders, but it kind of comes back to this idea of that they can keep something out in the first place. So that's the idea of home rule. I'm wondering if you can maybe explain a little bit more about where that doctrine of home rule kind of comes from. Is this something that's rare for a town to have?
Well, in fact, the concept of home rule predates the Magna Carta in Europe. And the king would often make grants of local authority to various, I don't know what they were, serfdoms in his, fiefdoms in his kingdom, but then would take that away. So in the Magna Carta, they said, no, the king cannot take away this idea of home rule. Localities have the right to elect officials and to make local decisions. So when the colonists came over to America, which wasn't America then, but when they came here and they were colonies, they brought with them that home rule. And when the people in New York formed their first constitution in 1777, they granted certain powers to the state, but they never gave away their home rule. And so that's sort of just this fundamental concept of this right to local elections, to make decisions at the local level, and to have this sort of control about local matters from locally elected people. And that has been further ensconced in the New York Constitution, and a 1963 amendment really made that, put some real teeth in home rule. So it's very clear what we've said in New York, and it does vary by community, although this concept of home rule just makes a lot of sense to people. It resonates. Like, of course we should have local control over land use decisions, and, who should make the decision? Somebody, some oligarch, some multinational corporation, from Switzerland, or should it be people in our town? So, so here in New York, there is this really long, very strong, predating our very first Constitution, this idea that local people get to make local decisions.
So you mentioned that the oral argument, I'm wondering if you can maybe lay out for us what the kind of two sides in this case are actually arguing. We understand it's kind of home rule versus the state's right or the state's regulation of energy, but maybe what are the more nuanced parts of the arguments that happened this last week?
So the Court of Appeals is our highest court. There are 7 judges on the Court of Appeals, and so the oral argument is when the attorneys for each side appear in front of those judges, and the judges get to ask questions. And so the questions and answers on that really were based, again, the towns, and there were 2 cases that were heard together. The town of Middlefield passed a very similar law to Dryden's, and these cases were joined at the Court of Appeals level. And their argument is that the lower courts were right, that even though the state has this transcendent interest in regulating the oil and gas industry, nobody ever intended, nobody ever meant for communities to not have the right to maintain their zoning, that's such a fundamental power of a community that if you're going to take that away, you don't take that away by implication, you don't take that away by, well, we think this is what the statute says. If you're going to take away home rule and local zoning, you have to say it very explicitly, and it wasn't, and it isn't explicit, and couldn't be explicit if the 6 judges that have already looked at this found that it didn't do that. That sort of by definition, it couldn't clearly take away home rule if 6 judges think it didn't take away home rule. Mm-hmm. The argument on the other side is that the statute says that local governments cannot regulate the industry, that land use regulation is a regulation of industry, and that there's this overwhelming state policy for resource extraction and energy development that completely obliterates and is more important than every other policy that the state has, including policies of healthy environment and preserving the environment for future generations, that energy development trumps everything. Mm-hmm. And part of their argument is based on this, there's an exception to the rule that communities cannot regulate the industry. There's 2. One says communities can regulate road use, and the other says that communities can impose taxes on production of gas. And so their argument is, it says you can't regulate, and then it says, but you can regulate roads and taxes, and you can regulate through zoning. And the answer to that is that when they passed this bill in 1981, it was a financial bill. The idea was to get money to communities and to the DEC to deal with gas drilling. And so they wanted to make it crystal clear that you could impose fees and restrictions on roads, which gas drilling can cause a lot of damage to, mm-hmm. and that wasn't a regulation of the industry, which it otherwise would be, because you're not talking about land use, you're talking about trucks in and out of a facility and closing off certain roads. That would be an operation. And then the property tax, typically property taxes are only on the value of the land. You don't tax someone on the value of the business that they operate on the land. But with gas production, that's exactly what it is. It's a tax on the operation of the business. It's a tax on production. So our side thinks that those two exceptions are exceptions to regulating the industry, and since land use regulation is a regulation of land use, not a regulation of the industry, that the fact that it's not a listed exception, you can't imply that there is a prohibition on zoning. Sort of the argument would be, you have a box of things that the community can't do. You carved out a box and said you can do those two things, but by carving out that exception, you didn't make the original box bigger. You don't make that expand to include zoning. If the original prohibition was regulations of industry, any exception to that doesn't make the prohibition, the first part of the sentence, bigger. It makes it smaller. And so those are the arguments. The court was very concerned about policy implications. What would happen if they made a decision one way or the other? What did this have to do with the SGIS, the Supplemental Generic Environmental Impact Statement the state has been working on? Although the Chief Justice concluded the arguments by saying that they weren't going to look at policy. Policy was for the legislature, and that, the two policies here would be, putting energy development above everything else, or bulldozing over the rights of communities. Neither one of those was very attractive, so they were just going to focus on the language of the statute. And we think if you look at the language of the statute, that it cannot properly be interpreted to take away zoning powers.
I'm glad that that's kind of the direction that you headed, because that was the next question I wanted to ask. If we kind of think about the fact that, so Anschutz sold these leases to Norse Energy, and then Norse Energy went bankrupt. So this case is the bankruptcy trustee for Norse Energy as the plaintiff in this case. Like, what would they get out of it, if anything, if the case were decided in their favor? And is this kind of becoming a test case across the state, and maybe seen that way from this kind of larger perspective of a town's ability to say, hey, we don't want this in our town limits?
So it absolutely is a test case, and that's why the industry has worked to keep this case alive, to bring in Norse Energy, to bring in Norse Energy after it declared bankruptcy, to have this, because they really want a decision, and they want the green light that they can come in and that they can frack anywhere and everywhere, that next to churches, next to schools, next to hospitals, wherever they can put together, and someplace that the DEC will issue a permit for, it shouldn't matter what anybody else wants. It's only about what they want, which you don't move to Ithaca, no offense, because of, it's this big industrial development area. You move to Ithaca because it's in the middle of nowhere, and it's beautiful, and you wouldn't be drawing people to come here if this was the worst parts of New Jersey or downstate New York. I mean, if you had to drive all the way to get here for that, why would you come? And people have invested and made their lives here. And the fact that these gas companies think they might be able to make some money, by doing this effectively off the backs of people and the communities by not paying the full amount of the costs because of these negative externalities on communities, a large majority of the people just really don't think that that's remotely fair or reasonable or the way we should be proceeding as a society.
So I know you mentioned that it's going to be a little bit of time before the decision, but maybe we've got about 30 seconds left. If you could just give us your predictions for how you feel things might end up.
We believe that the Court of Appeals will uphold the town's rights to say no, that they would have to totally drastically change the law. That could happen, but there's really no reason to do that. The implications would be devastating to communities versus allowing communities to have the right to say no, upholding home rule, and continuing with New York's tradition of caring about what communities think.